We have some conversations about the PowerPoints.
Your Honor, the court did share, the state did share its PowerPoint with the defense. We went through and made any corrections to typographical changes or needs in the PowerPoint itself. They are actually able to access the state's PowerPoint in real time, so they can see any change or anything that we made. We actually took out most of the photographs that we initially included, particularly most of Christian Evinger. So I have not heard from anyone on the defense team that there was any other objections. We added back in Rodelius Ryan's party opponent admission on the date of the murder of Jamari Holmes. And we would like to, but have not, add the third homicide victim's photograph in, and that was it. So I have not heard anything from anyone regarding any of the changes.
Okay. Do I have any further objection, or are there any further objections to the state's PowerPoint that you all, or changes that you all individually have objections as to going forward?
I would propose, sorry.
Go ahead, Mr. Steele.
No.
Your Honor, I understand the court's ruling, previous ruling, just renew my objection that I think because the state didn't turn these over, they should be excluded.
Mr. Steele?
Yes, Your Honor, I was unaware that there were changes. I apologize. No one told me that. I didn't get an email to that or text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. I've been waiting. Right here, in the hallway, and in that other room gate. So I understand that the state updating something, and not realize that that's what they were doing.
Your Honor, we did indicate that we would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So, any further objections?
Yes, Your Honor. I didn't know that they were changing.
Yes,
it.
Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
Again, they misquoted it?
Yes, they did. It says, "I bet YSL make the news tonight." That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay. I will take out the word tonight. He's right.
Anything further? Mr. Shard, did you rise to?
Well, I'm just seeking clarification. I, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this PowerPoint, and at the appropriate time, we would, Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argumentative slide in Mr. Sharp's PowerPoint that we would like to address before we're in front of the jury. You can't hear.
Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team, and the other members of the state's team that have looked at the PowerPoint, they were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp over the lunch break shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of a jury again, as this I think is the appropriate time to do so. But the changes that the state made were available and published to everyone on council for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with a new version of the PowerPoint.
That's not what I told you all to do. I was pretty clear. I said, y'all over lunch, just take a look at the state's PowerPoint, make sure you have no further objections. I didn't tell you to email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. Yeah, we were waiting, we had voiced some concerns already, and we were waiting on a new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay, here's what I'm gonna do. I'm excluding the PowerPoints. Y'all are just gonna have to make this thing up the whole way. Yeah, just make an opening statement. No PowerPoints. Let's bring our jury in. No PowerPoints, because you all did not do, hold on, I'm starting, you didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done. And my orders to you are not aspirational. They're given for a reason. And when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
If I could address the court, Archie Matthews from Mr. Hugh. In terms of what we have done here on our team, we have provided our opening statement to the state of Georgia as well as to every other person on the defense side. We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Hugh. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to memory, Judge. I'm depending on my opening statement to present to the court, to the jury, Judge. So I'm asking the court to reconsider its position as it relates to Mr. Hugh. Respectfully.
All right. Mr. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
Now I did everything the court demanded,
All right.
so I'd like to use mine.
Okay, all right.
And Your Honor, to be clear, on behalf of Mr. Stillwell, I sent over all the...
When did you send it?
On Friday, I sent all the photos of the exhibits I plan to use or the demonstratives I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I took a picture of. And I have it with me right now. But I did not have that on Friday when I sent that over. I did not have custody of that object. Regarding the PowerPoints, when the state finally handed over their PowerPoint and said that they didn't realize they were supposed to hand over the entire PowerPoint or get these exhibits, which they didn't do that either, by the way. I did. I sent them out of an abundance of caution my entire PowerPoint. So.
And Your Honor, I don't object to, generally speaking, the PowerPoints that have been shown. What the state did do was exactly as the court directed during the lunch break, as Mr. Matthews was able to see, we provided to each member of the defense team every change that we made. And respectfully, Your Honor, we would also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't, actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours in doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we were going to end up dealing with a lot of objections. And I mean, I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had to start having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That, obviously, very few people adhered to the court's instructions, and we find my words to you a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So,
Your Honor, we have, as well, as I stated, we provided the photographs we intended to use
when did you provide them?
Friday before 5, Your Honor. The language that is in the PowerPoint are the words, our opening, our things. They all have that. Everyone has that. I don't believe that there is a general objection to that. Every objected to portion of the PowerPoint that the state has, Your Honor, has been modified to address those objections. And we just asked the court to allow the parties to proceed as we have been proceeding with respect to presentment of opening statements. Additionally, Your Honor, I am not objecting on the basis of anyone having given the state the PowerPoints today. I'm not objecting as it relates to when anyone gave us the PowerPoints. I only objected to these photographs that were provided to us just a few moments ago on the basis of that they were argumentative. And I want to bring that to the court's attention. If the court decides that they say, even though they're argumentative, the state has, we can get past that quite easily. We would just ask that the court allow the parties to proceed as we have.
Are you referring to I'm in possession of 2 emails with photographs. I'll mark it as the next court exhibit in order. One of them is, it has the subject of the state objects to arguments contained in Shannon Stillwell slides below, and I have a couple of, it has like 3 slides.
Yes.
I'm going to mark that as the next court exhibit in order.
Yes.
Mr. Sharp, why don't you believe this is objectionable? It would seem to me it's got pictures of a couple folks here in our facility, and a picture that's probably more prejudicial than probative, and it has somebody that purports to be an inmate. So why wouldn't that be?
I don't think, Your Honor.
Yes.
I don't believe. I'm not seeing the email. I see an email saying the state objects to use of these photographs during opening.
It's got your 4 slides: state's key witnesses, Nicholas Robinson, and then Nicholas Robinson, a.k.a. Spencer Wright. Those are 3 that I'm looking at.
It's not showing that in my email. I'm seeing 2 pictures of jail.
I got that one too, which I'll mark as the next court exhibit in order, and that's the 2 pictures that you referred to. And it has the state, subject matter is the state objects to the use of these photographs during opening.
Could I see what we're talking about? Because I don't have it on my email.
Sure.
I'm not seeing it.
Christina, can you mark these in the next court exhibits and then show them to Mr. Sharp? Counselors, you can approach and take a look at it.
And Your Honor, the court is on the right.
Hang tight. Which one did you mark it as, so we can,
I have, it's marked Exhibit 2. And-
all right,
and
courts
it-
two? Or
Yes.
next court's exhibit in order, okay, all right.
And I wasn't on that email, and that's fine, I just wanted you to, that's why I hadn't received it. So, this case is going to involve,
Objectionable.
I'm allowed to preview the evidence that I believe that will come out. I not only believe, but I know that several of the witnesses in the case, which I'm going to discuss in opening, became involved in this case once they were in the Fulton County Jail. They were jail inmates, okay? Now, I'm allowed to preview the case in that way. To the extent, if the state has a particular argument or objection to one of the photos, then we can talk about that, but...
Thank you.
Okay.
Court does.
Well, I can alter my...
I mean,
So what is it you want me to alter, Your Honor, to avoid?
the picture, and if
Okay.
if the state doesn't have any objection to the, you saying anything about any other witnesses in custody, then, that's certainly within their purview.
Well, the case law, as I understand it, allows us to preview the case and let the jurors know in advance that witnesses were in custody at the time they made statements. That is completely appropriate as under the law as I understand it. Now, if there's a problem with the pictures, as I said, Your Honor, I will remedy that. That's not a big deal.
I would ask that you take the pictures out,
Okay,
okay?
that's fine.
What about the argument in the pictures seem to be, and that would solve that issue. So what about the other issue about the slides?
Well, they also said this Nicholas Robinson one. I'm not sure what their objection is. I will be letting the jury know, which will come out in evidence, that a man who claimed to be named Nicholas Robinson was arrested on October 19th, 2015. He's an important witness in this case. They will know, the evidence will show that he was interviewed by Detective Thorpe, and he gave his vantage point of where he was, and he told a story which involved the guilt of 5 people that are listed on this slide. And that evidence will come out at trial, and I don't see anything objectionable about this at all.
All right, Ms. Love.
Judge, I don't object to Mr. Sharp telling the jury the words that he has shared with the court. What I object to is the imagery that is depicted in the...
You mean the person that's in a uniform as well as the purported condition of the jail in that lower one?
Correct.
That's a separate slide. That's a separate slide. These are 2 separate slides. I just want to make clear. These are 2 separate slides. So I'm saying that I'll take out the pictures.
And also the giving of the false information. So the only problems that I have with the language in the other slide is that part of that information is improper impeachment, that Mr. Sharp would not be able to introduce at trial.
Except that...
And I don't have any problem with Mr. Sharp telling the jury that the evidence will show something about Nicholas Robinson, but he has listed all of the arrests for Mr. Wright, Mr. Spencer Wright.
Who is Nicholas Robinson, Your Honor, just so the record's clear? Your Honor, as Your Honor knows, we're allowed to impeach with prior prior convictions.
They gotta be called first, right?
But we are also able to impeach with bias.
Okay, but-
And the fact that this gentleman was arrested, Your Honor, that's the central crux of this case, and it's something that the jurors need to be made alert and to look out for as this case is presented. The bottom line is Mr. Wright, who identified himself as Mr. Robinson, was arrested on felony charges and probation violations on 10/19/15. And then he reached out to APD and said he wanted to give information. And then he met with Detective Thorpe. Nothing I'm saying is incorrect. It's all accurate. It all would go to his bias and motive and reasons for coming forward.
All right,
And
so you're saying this is what he was arrested on the 15th?
right,
On 10/19/15?
correct.
Okay, all right. Okay.
And quite honestly, off the top of my head, I don't know how those cases were resolved, but they were biased at the time that he made those
Are
statements.
you saying that because the evidence will show that he then gave information against your client
Yes,
or involving your client?
yes.
And Judge, I don't have a problem with him saying that Mr. Wright was in jail. I don't have a problem with him saying he had open charges. It is the listing of the specific ones that
What?
we objected to.
I don't know why that's
Because they are
objectionable.
not convictions, and that is not the proper method to
Yeah, I would
show
agree with that.
bias.
So you can talk about, unless you get them in a proper format, yes, you can talk about if you have criminal charges, that would be appropriate. What happened as a result of that, but I think the longer listing of that, because you said you don't know what happened to him, so
But the reason I'm saying that is because I think it's irrelevant, because this is really about bias.
it's not proper though. It's not proper format. Bias is fine. You can talk about the.
But he had the bias because he was facing these. Certainly, if someone's arrested
You
for
just
murder,
can't. You just can't mention the individual charges themselves unless they're in the proper format.
I
okay?
understand. But my only point would be, Your Honor, certainly if someone was charged for jaywalking, arrested for jaywalking, and someone else was arrested for murder, the bias, the level of bias would be different. So,
Okay, but what does that have to do with them not being in proper format, though?
because
in
the
order-
jury is allowed to understand specifically what bias the person has. Not that they're just in jail, but what they are facing.
If
I'm not
you
giving it in
can get
terms-
it in the proper format, then it can be, and you can tell them about that. Do you know what happened in these particular charges?
Well, but they
Is
had been
Nicholas
resolved
Robinson going to testify?
at the time that they,
Answer my question.
What's
Is
that?
Nicholas Robinson going to testify?
if the state doesn't call him, I will.
Okay, well then, at that point, then it might be appropriate for you to get into that specifics. But unless you're going to package that up, and certainly that's not, you can decide that. You don't have any responsibility to present anything on behalf of your client. But in order for you to delve into it, it has to be in a proper format. I would agree with the state with that. I would sustain that objection.
Well,
But you can talk about arrests, you can talk about pending charges, you can talk about that, you'll present evidence sufficient to show that he's got an axe to grind, he's got bias.
So you're, just for clarification, because I want to get this right, we're saying your instruction is that I can say that he was arrested and he had pending charges, but I just can't say what those charges are.
Until and unless they become you get them in the proper format, or you have a witness you can lay a foundation for those. Okay?
Okay, and the third thing, Your Honor, is I have a Fulton County jumpsuit. This is the same uniform, not actually the same one, but is the same make and model that a number of the state's witnesses were wearing when they inserted themselves into this case. I wish to preview to the jury and say the evidence will show that these individuals were in Fulton County custody wearing this jumpsuit at this shirt at the time that they gave statements. That's previewing the case. There's nothing objectionable about it. I'm not going to put it on. I'm not going to jump around the table. I'm not going to do anything with it. I'm just going to show them and say this is what they're wearing.
All right. Madam?
Judge, I think that is appropriate for argument, but I think that saying, and they can, certainly Mr. Sharp can tell the jury that the evidence will show they were in custody, all that, but that, I would argue would be more appropriate for a closing argument. And that is argumentative.
I believe it is appropriate for a closing argument, but I think it's also appropriate for an opening argument, and I'm allowed to use demonstratives to try to get my point across to the jurors in a way that will stick in their mind, because we all know that they're going to be listening to 15 hours of or 10 hours of opening statements and 6, 9, whatever of testimony in this case.
All right, I'm going to sustain that particular objection and also remove the, ask you to remove that picture of what purports to be as, I think it's a cell or something like that. So remove
Yes.
those. So yes,
Remove the pictures,
and lose that for the time being. Sure, for the time.
okay, and take off the specifics.
Take out specifics. Okay.
All right. Thank you, Your Honor.
All right.
Okay, Your Honor.
Hold on one second. You did it.
Oh.
You did it.
Mr. App, have your client put on his shoes. All right. Anything else? Anybody else?
Your Honor, there was not anything with respect to any of the defendants, but there was a matter that probably is best addressed with a member of defense counsel at the bench briefly. It is a short matter.
Okay.
All defense counsel?
Either one, it doesn't matter. It's not substantive.
All right. Put your headsets on, please. They have to also hold it. All right, can you hear me? Thumbs up? Okay, all right. As long as we don't have any other issues?
Thank you, Your Honor.
Okay.
Thank you, Your Honor. And I want to make certain no objections to Mr. Trank.
Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, and I got the last one. Number 19 is argumentative. Number 41 through 47, 51, and 54 is the law that they take from the court. I would object to those numbers.
And Your Honor, I believe that the argument about the law was raised prior to lunch.
Hold
Mr.
on. As it pertains to number 9, I'm going to mark the state's second PowerPoint as the next court exhibit in order. In terms of number 19,
That is,
we didn't chase the lyrics to solve the murder. We chased the murder and found the lyrics. Is that what you expect the evidence to show, madam?
yes, it is.
All right, I'm going to overrule that objection. What's your next one, sir?
41.
41. Judge's rules. All right, this is the note-taking that I already gave them.
Didn't change it.
Ms. Lowe, why are we rehashing this since I've already told them that?
Your Honor, why are we putting it
Why
back?
are we rehashing that? I just told them that. I told them what was in 41, as well as 42.
Your Honor, I can take them out. I don't mind. I was just, it's part of the opening that I wanted to emphasize, but I can take it out.
I'll sustain it. You can tell, you can tell them that it's
Okay.
fine. I'll ask that you take out 41 and 42. So I sustain that objection, Mr. Steele.
So
what about 49, 43? Did you have an objection, sir?
Correct.
Your Honor, is the court directing me to take out the picture, or can I just take out the word "take notes"? Because
Oh, no, take notes is fine.
Oh, okay.
He didn't object to that.
Okay.
He's objecting to 41 and 42, which I'll sustain the objections to that. And then 43, let me look at it.
Oh, okay. I'll take that out.
Okay, I have not instructed them on how to judge credibility as of yet. So 1 through 7 would not be appropriate at this time.
Okay. So.
But you can leave in bullets 1 and 2.
This 1 and 2. Okay. So is
You
it?
must remember in any way that works for you what they said on the witness stand. That's fine.
Okay.
And use whatever memory aid you need, just not to remember what you heard, but to remember who said it and how credible you found them to be when they testified, or some words to that.
Okay.
But the other things, I have not instructed the jury as of yet on how to judge credibility. I didn't give them a preliminary charge on that, so if you could take those out.
Okay.
1 through 7, please.
Yes, Judge.
Does that suffice, Mr. Steele?
And as.
Or do you still have an objection to 43?
Yeah, and I appreciate what you said. I will accept it, but prosecutor's opening statement, this is Johnson versus State 261 Georgia Appeal, 98 Division 6C, as in Collette.
Charlie.
And Charlie.
Just one, Charlie, okay?
I heard Collette.
Just one. We gave you the military alphabet. It's on your desk.
No, I have it. That's why I say and Charlie.
I only want the military alphabet, okay?
Collette is not life.
I know. A very sweet lady, okay? All right. So,
But it says the prosecutor's opening statement should be limited to what the prosecutor expects the evidence to prove a trial. So I don't see why the law is coming into their opening statement. That's my objection.
I removed 41 and 42.
For clarity's sake, Your Honor, I did and have been editing as the court has directed. So my 41, because I took out a whole slide, may be different. For clarity, the one that the court is referring to is 41. Is that the one where we are saying your assessment of a witness's credibility, blah, 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 all of that?
No transcripts in the jury room.
Okay.
I've already told them that too. So why don't you just do this?
I can take that.
Why don't you just your last slide can be take notes. And you can tell, I think that what you told them, what would be more than proper argument would be, hey, remember what the court told you, and take notes in a way that works best for you, and use whatever memory aid you need. And remember, that would be more than appropriate, and I think would not be objectionable.
So I'm also taking out the one that says, please pay attention. Is that what the court has directed? Because I'm going to hit delete if it is.
Yes, I would take that slide out, okay?
Okay.
Anything else? Can we call for our jurors now?
Same thing. I think you ruled on 45 or the old 45. 45.
I don't have the old 45 right here. They've gone through, the new one goes through 43, sir.
Okay, as long as it's removed, then yes, I'm satisfied.
Okay.
Your Honor, and I want to make sure that we all have everything the same. So just to be absolutely certain, I'm going to share again with the court, because the numbers that I just heard the court reference,
I have the new slideshow you sent me, which goes from 1 through, I didn't go down far enough. Okay, all right. The new slideshow goes 1 through 56.
I took out
And
some, yeah.
so I'm gonna say take out 41, 42, 43.
And I'm changing them in real time, so I'm taking them out.
You need to take out 44.
Okay. Is that the one that starts with judge's rules?
No, please pay attention. You need to take out 41, 42, 43, 44, 45, I will leave in over objection. Okay, I'll let you leave in 45 and 46 over objection. 47, judge's rule, 47 needs to come out.
So the one about with the finger pointing, that,
Finger in the eyes are fine.
okay. And I took out judge's rules,
I got 47.
and I think I've already taken out 47.
47 is judge's rules again.
I took that out.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But I'll take out the other ones that you just mentioned.
Okay.
So,
Waiving my mistrial, thank you, sir.
say again?
I apologize, without waiving my mistrial, thank you, sir.
All right, and your motion for mistrial has been denied, and I've noted your objection for the record, sir.
And confirming everyone has 1 through 52 with the edits that the court has directed.
It's on the same old link, right?
Yes, it is.
All right. Anything further? All right. Yes.
Just don't want you to get an objection to the opening charge. We can do that later before we break for the day. Want to move forward.
What are your objections, sir? To the court's, the court's preliminary instructions.
First, before the court talks in terms of guilt and innocence, and I would object to any of the phrases that use the term guilt or innocence. I object to the use of the phrase, the purpose of a trial is to discover the truth. No, it's not. The purpose of a trial is to determine whether the state proves beyond a reasonable doubt the allegations in the indictment, so I will object to that. I object to the fact that the court, I believe, is going to allow the jury to frame questions to provide to the court. I was unaware that the court was going to...
No, I'm probably not going to do that, Mr. Steele, Mr. Harvey. I do that because that's part of the pattern charge, the pattern preliminary charge. So and most of 9/10 of the time, they're not going to ask any questions. And if they do, I will then present that question to you all for your consideration, and I may or may not ask it.
Okay, well, I have,
But you objected to it.
I object to the process.
Okay.
Sixth Amendment.
Anything else?
State Constitution. No judge has that.
Okay, all right. And I'll note your objections for purposes of the record, sir. Okay, all right, can we summon our jurors, please?
I go ahead and share.
Yeah, put up the last slide, I believe that was Mr. Ryan.
Okay. I'm gonna go back to the Zoom. This is Zoom. Okay. Did you just send it?
Yeah. They're right.
Has it come? Has it come? Okay.
Yep.
Okay. Just give me a second.
Oh, ladies and gentlemen, please be seated. We're just going to wait on one. We'll wait on one. We're waiting on one juror, ladies and gentlemen. Just be made easy. Just a second, please.
I'll do the present counsel.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, how was your lunch? All right, good, good. Okay, ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state council earlier referred to some representation of the parties, and I just want to remind you two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
Thank you, Your Honor.
All right.
And thank you, ladies and gentlemen of the jury. I like the court. I hope you all had a great lunch and can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them include the following: conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms, among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state met its burden. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. It will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct, before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-prossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence will show is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're gonna participate in YSL through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is nothing more than certain crimes, the crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well, to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect the court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants, they wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have, through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide, has the state proven its case? Rodelius Ryan. Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old, and that in February of 2019, Rodelius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car, and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car, where Jamari Holmes, not even 20 years old, was seated and hit him in the back of the head with the bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodelius Ryan doesn't say, I bet I make the news. Rodelius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to and attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodelius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodelius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodelius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say, friendship over females. He didn't say lay like over buddies. He said slime over sluts. Slime over sluts while posting a YSL gang hand sign with the caption slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodelius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, "Fuck YFN." YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodelius Ryan didn't post, "I bet I make the news." He said, "I bet YSL makes the news." Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activity. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case, YSL members, stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed his actions showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and a debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings. Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone, where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Tinquarius Mender, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he can give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun, two people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Delmisha Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held him at gunpoint, and demanded their belongings. You'll hear how they directed Delmisha Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Delmisha Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffrey Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Domisha Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard after Woodard told Mr. Huey she'd see him in court. He said, "You will die if you put the police on me." Showing their association, showing their agreement, showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Tinquarius Mender was an inmate at Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it, and then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they're crimes. They're listed because they are actions. Actions that the legalese for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. And somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking, state, really?
It's an argument, objection.
I sustain the objection.
Thank you, Judge, I'll move on.
Move on, that's argument.
The evidence is going to show that these steps that they took are akin to you just going out and get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime, it's just an act, an action. The evidence is going to show that the defendant Jeffrey Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffrey Williams rented a car, notwithstanding that Jeffrey Williams had his own cars, but he rented a car which happened to be a silver Infiniti sedan that other YSL members, among them Demonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low. in the wake of the Donovan Thomas murder. Later that month, on January the 26th of 2015, Demikion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant, Jeffrey Williams, looking into the camera and saying these words. So, I think lied to their mama, lied to their kids, lied to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities. He didn't say that's from me. He said that's from me and YSL. And as the evidence will show, that's akin to him saying that's from me and my pack. Kendrick's and Williams' words, there's been a lot of talk about lyrics. But y'all, the evidence are gonna show in this case, we didn't chase any lyrics to solve any murders. Law enforcement in Fulton County chased the murders and found the lyrics. They're investigating, they're finding out who committed it. And after doing all of that, they happen upon lyrics. Lyrics that have an uncanny similarity to very true and very real and quite specific events, as the evidence will show. Jeffrey Williams' words that he promotes through songs with beats behind them, they aren't random. He tells you, as the evidence will show, take this shit to motherfucking trial. I rep my life for real. For slimes, you know I kill. Trial, I done beat it twice, Kendrick's. I'm undefeated, like feds came and snatched me. I don't know, no point in asking. I was on what? Bleeding. Stuck like a magnet, bitch ass nigga. If we whack them, my young niggas pulling up, Bentleys, Austin Martins, Rares, Teslas, strapped with an FN. You're gonna hear a lot about FNs. FNs galore. From here to 2015, FNs all throughout the incidents that are involving gang members, YSL. Watch me whack that bitch. Pop him like assist. Glock with the assist. Incidentally, the gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch, it was a Glock. Again, we didn't chase the murders. We didn't chase the lyrics, rather to solve the murders. We chased the murders, as the evidence will show, and in the process, we just found the lyrics. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity. He tells you, we committing them crimes. Hop out and shoot. Roll one up for the gang. He's not using gang colloquially. The evidence will show he's telling you they are a gang. You want to be slime? Children of Fulton County, go catch you a body. Me and Lil Bro.
Object to that.
The evidence,
How would you expect the evidence to show, madam?
it is indeed, Your Honor.
All right, I'll overrule the objection.
The evidence will show that when Jeffrey Williams is saying me and Little Bro, we used to steal from the store, we had to stick it and go. He's talking about himself. The evidence will show that this is the manner, through the music, that he has been blessed with the opportunity to be able to release and gain wealth from. Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shot him yet, y'all he's getting soft. The evidence will show that there's no place or need for that kind of eating or statements when all you're doing is making music. And to clarify and put a very clear and fine point on it, the evidence will show that no one is attempting to take away from Mr. Williams the fact that he has had a lucrative rap career. The evidence is simply being put before you to show that he is guilty of committing the crimes that are laid out in this indictment. That he and his fellow YSL gang members and associates on trial before you now agreed to participate in this organization through the illicit, illegal activity listed in this indictment. And that they further committed all the other crimes listed in the indictment beyond count one. Because as you'll see, count one consists of 191 overt acts. Acts that aren't all crimes, they're just acts. But counts 2 through 65, the ones that have these defendants' names on them, are the ones you're here to evaluate whether or not the state has proven. Actions and words, words and actions. The evidence will show that this was Donovan Thomas in life, that on January 10th at 2:15, about 7 o'clock in the evening, Donovan Thomas was living his best life. He was up at the barber shop at 330 McDaniel Street. He had paid for a bunch of people, a bunch of kids to get their hair cut, and you'll see that he is out there enjoying himself. The last actions that he took while he was fully alive and healthy, joking with his friends. You'll see that they didn't even see it coming. You'll see evidence that Donovan Thomas was literally in the middle of lapping it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. The evidence will show that this act wasn't done secretly, it was done openly, notoriously, almost as if to send a message. We did it. The evidence will show everybody knew who did it, because it wasn't done secretly. The evidence will show that this act didn't happen in a vacuum. There were things that led up to it. An argument at Club Crucial, or Club Brucial, as my defendants may like to say, that involved a YSL associate by the name of Kenneth Copeland and a member of a rival gang. Kenneth Copeland gets jumped. He's flashing money because that's what they do. It's ladies' fight night and they're out there flashing money. Kenneth Copeland gets jumped. Diamante Kendrick jumps into action, goes to Kenneth Copeland's defense, punches out a member of the opposition, and then shots are fired. Shell casings. Shell casings are all throughout the evidence that you'll see and hear in this case. Remnants of the violence inflicted on this county by YSL and its actions. Shell casings are fired in between January the 6th and 7th of 2015 and January the 10th. Other incidents take place and they lead to the ultimate gunning down of Donovan Thomas. As the evidence will show, in the ensuing months, there were series of shootings and retaliatory shootings. Most notably, the mother of rapper Rayshawn Bennett gets shot. Her house is shot up twice. She gets shot one time. And the evidence will show that there is not always cooperation, because there is a code that people adhere to when this type of violence is surrounding them. No snitching. So the evidence will show that even as people were getting shot, even as people were bleeding, even as people were being taken to the hospital to have their wounds attended to, they weren't always forthcoming. They weren't always willing to talk to and to trust law enforcement, not even if it would serve their own purposes. The evidence will show that members of YSL ultimately, as a result of those shootings and retaliatory shootings, ballistics or firearms matches started coming back to various people. And then one YSL member, Quindaria Zachary, he gets caught with a gun. The shell casings from that gun go to match some of these shootings. Quindaria Zachary is caught. He starts telling. The evidence will show that Quindaria Zachary was a straw purchaser for YSL. A straw purchaser is nothing more than somebody who goes and gets guns for somebody who's not supposed to have them. And that's what Quindaria Zachary did. Firearms found in the hands of Kenneth Copeland led to further revelations to the police and law enforcement. The evidence will show members of YSL were so eager, so gangster about acting on behalf of and in the protection of the defendant Jeffrey Williams and YSL that when Wayne Carter, otherwise known as Lil Wayne, came to town to perform at the compound while the defendant Jeffrey Williams was performing in Lil Wayne's hometown, according to word from the people that talked, getting booed at the time, members of YSL show up at the compound, locked and loaded with guns. Evidence will show that security knew to be on the lookout for members of YSL. The authorities were alerted to ongoing public rifts and back and forth between the defendant, Jeffrey Williams, and members of his gang, and statements being made publicly on social media about, towards, and threatening Wayne Carter. So when Tyrone Dennis, who is working an extra job, he is a law enforcement officer. At the time, he was an investigator with the Atlanta Police Department gang unit. So when he's there working his extra job, and he sees Walter Murphy, one of the founding members of YSL, show up with the defendant's sisters, and Trontavia Stevens, and ultimately Jimmy Winfrey with guns, When he sees Walter Murphy try to secret a gun underneath the wheel well of a car, he calls him out. He's like, what are you doing? Walter Murphy's like, oh, hey. The evidence will show that the YSL gang members that showed up at the compound that night were not allowed entry into Lil Wayne's concert, his venue. So what they did was they waited until Lil Wayne leaves, gets in his tour bus, and is attempting to leave the area. They get up beside the tour bus and they unload bullets into the man's tour bus. Bullets. For nothing, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night. But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity, their willingness to act on the behalf of, their willingness to exact violence upon anyone who threatened the position of the criminal street gang calling itself Young Slimelight. You'll hear evidence that after being arrested, or actually when he was approached back in 2014 about an armed robbery he allegedly committed, YSL member and associate Trontavia Stevens was seen bearing tattoos on his hands, ROCCREW, Cleveland Avenue. And that on his side, he had YSL. And Detective Mark Belknap inquired of him, what's that? Though Belknap knew, because he had been working the streets of Atlanta for a long time. He was familiar with Right Crew. But as gang investigators, they're taught to interact with and talk to people when they see indicia of criminal street gang activity. You'll hear that Trontavia Stevens told Belknap, well, Rock Crew is the name we used to call ourselves. Then we started going by YSL, which stands for Young Slimelight, or it did stand for Young Slimelight. But then, when my friend Jeffrey Williams started becoming successful, we changed that name to Young Successful Life. The words of a member of the gang himself. The only time, as the evidence will show, that members of YSL don't want to call themselves and acknowledge that they are in fact a gang is when it would be to their detriment. The evidence will show that any other day of the week, they are loudly and proudly promoting their criminal activities. Donovan Thomas, he was driving this Chevrolet Tahoe the night he was gunned down. The evidence will show that this location here is the barbershop right up from the Texaco at the corner of McDaniel and Northside Drive in Atlanta, Fulton County. We asked you during voir dire, you heard us say, how many of you are familiar with this area? This is that area. The evidence will show that that is the way that Donovan Thomas looked last time his loved ones saw him. That his life was swallowed up in that crater created by YSL in the Cleveland Avenue community. And the words that they found while looking into this murder, spoken by members of YSL. We don't speak about shit on wax, but indeed they do, as the evidence will show. They just kind of thinly veil it. We are known to kill the biggest cats of all kitties. Donovan Thomas in the community, he was a big homie. He was a friend to a lot of people. He was a big deal. And it touched a lot of people, as the evidence will show, when his life was taken. The words that were spoken, we known to kill the biggest cats of all kitties. How coincidental that Donovan Thomas was gunned down. And these were the words later spoken by members of YSL. The evidence will show that it's not coincidental at all. 100 rounds in a Tahoe. 100 rounds in a Tahoe. The evidence will show that the lyrics released by YSL members, the lyrics they chose to speak, they bore a very eerie significance to real life. 100 rounds in a Tahoe. And you'll see that Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed Donovan Thomas and his car on January the 10th of 2015. This that slime shit, killing 12 shit. The evidence will show that 12 is the word that is commonly used to denote law enforcement. And speaking of the young people whose innocence and whose lives were swallowed up by that crater created by YSL, Christian Eppinger. He's not before you today, but he is a co-conspirator of these defendants. He is a YSL member and associate who got YSL tattooed on his face at the tender age of 15. He repped YSL continuously and notoriously throughout his social media. The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taravia Hill at gunpoint in front of her child. And that at his sentencing hearing, Taravia Hill, seeing a young black boy, who could have been her brother, cousin, she actually advocated for Christian Eppinger's lenient sentencing. So Christian Eppinger, he wasn't sentenced on what he was originally charged with. With the acquiescence of the victim, Christian Eppinger received a lesser sentence. He went to prison for a short time, and within less than a year, he committed an armed robbery. And when law enforcement officers are out there looking for Christian Eppinger, who incidentally constantly posted on social media with the guns and his gang signs and the green emojis with the gun pointing to the camera or to some other emoji talking about how he reps hard for YSL. When law enforcement officers, specifically a law enforcement officer just 30 years old by the name of Officer Rogers, when they go to apprehend Christian Eppinger on this armed robbery he committed after being released from prison, having robbed Taravia Hill, they do everything they can to take him in without causing any harm to Christian Eppinger. But you will see that while he's being taken into custody, what Christian Eppinger does, he takes the firearm of this young officer. He pulls it out of the holster and he fires, putting 7 bullets in Officer Rogers. The evidence will show leaving a law enforcement officer with PTSD after he has tried to humanely apprehend a member of YSL. The evidence will show that this person depicted here is Quantavious Greer, also an associate, but perhaps more importantly, the brother of the defendant, Jeffrey Williams. Christian Eppinger was so deeply entrenched, ingrained with loyal to YSL. He's even posting free bitch as Quintavious Greer served a sentence for murder. Who said they want smoke? Christian Eppinger, as he's calling himself YSL Briss. Note that Chris does not start with the letter B, but it does when you're associating yourself with a criminal street gang who aligns itself with the Bloods. And that's the tattoo that Christian Eppinger on the side of his face proudly publicized on June 27, 2015. He wasn't even 16 yet. New ink with the green snake emoji and a red heart. The evidence will show that though you will hear over and over the names of the 6 people on trial before you today, that the 6 people on trial before you are not the people who were most viciously affected by the acts of this criminal street gang. The evidence will show how far members of YSL are and were willing to go to act immediately on behalf of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely behind another YSL associate, who then phoned up the gang who was posted up at the trap house. And in minutes, 2 more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, 2 YSL associates followed behind him. And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened, law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned, the YSL gang members said, we got a call that one of us needed some help. He didn't know who this was pulling up behind him, so we just responded. You'll hear that investigators Gaither and Dennis said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy needs help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL gang members and associates on behalf of their leader when they felt someone disrespected Jeffrey Williams or any other member of their pack, they made threats. Not quiet, whispered threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. This about to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy, of the agreement itself. the agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment. There are numerous victims that you're going to hear about. Shannon Stillwell is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwell is alleged by one of his own crew, by another YSL, two other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwell was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people as having committed the murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig to find out whether the people who were talking were actually in a position and a place to know the stuff that they talked about. And what they learned was that that person originally relied on by Investigator Thorpe, that person was just lying. And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further. The evidence will show that our office did not just stop at the word of one YSL member. The evidence will show that yet another accomplice corroborated the words of the first YSL member that talked. The evidence will show that cell phone records further corroborated the information law enforcement was getting from these people. And ultimately, Shannon Stillwell, Demonte Kendrick, Justin Cobb, Javoris Bradford, they were all indicted in this particular instrument that you'll have for your consideration. But the only two people who are in front of you for you now to determine whether or not the state has met his burden are Demonte Kendrick and Shannon Stillwell as it relates to Donovan Thomas's murder. However, between the time that this indictment came down and the time that our office decided, no, we need to look into this investigation some more, Shannon Stillwell was released from jail. But he had to wear an ankle monitor as a condition of his bond. The evidence will show that during the time in 2015, after a lot of arrests were made following the murder of Donovan Thomas, that the violence in Fulton County, the gun violence that had continued over the course of that year, it kind of subsided a little bit.
Basis.
Argument.
I sustain the objection.
Yes, Your Honor. The evidence will show that around 2019, 2020, law enforcement investigators, they started noticing some activity on the part of gang members. They started paying particular attention. One of those investigators was investigator Marissa Vitorito. You'll see and hear from investigator Vitorito, and you'll learn that one of her jobs as a law enforcement officer, one of her background experiences was that she was a probation officer, so she had a lot of information about a lot of YSL gang members. You'll hear that initially, after Shamel Drinks was gunned down, Detective Hogan with the Atlanta Police Department, he didn't have any leads. As a matter of fact, he came back to the precinct lamenting the fact that he had no leads on this homicide that just occurred at Windsor and the I-20 entrance ramp. Young man killed, gunned down inside his car. When investigator Vitorito began talking to Detective Hogan, she saw that Detective Hogan did have some footage from the gas station right up from that location. And that investigator Hogan was looking to find the people in the gas station because that gas station was the last place that Shamel Drinks was seen alive. One of the people in the surveillance footage was wearing a very distinct hoodie and coat. And as it would happen, investigator Vitorito had hours earlier been at a Waters Road location, one of YSL's hangouts, as the evidence will show, a place from which they conducted transactions, and that the Waters Road address had been shot up, and investigator Vitorito happened upon Shannon Stillwell and other members of YSL in the same outfit he was seen in the surveillance video on at the time Shamel Drinks was inside the gas station. The evidence will show that further investigation revealed that Shannon Stillwell was wearing an ankle monitor at the time that Shamel Drinks was gunned down. And that ankle monitor put him right there at the place that Shamel Drinks took his last breath. The evidence will show that in this murder, much like in the Donovan Thomas murder, there was a rental car involved. A rental car which these defendants had gone and gotten the windows blacked out, tinted on, earlier the day that Shamel Drinks was gunned down. Tinted the windows of a rental car. The evidence will show that it was to evade being seen by the opposition. The evidence will show that as a result of all of this violence and activity, during the midst of it all, investigator Vitorito had secured a wiretap for Demekion Garlington, YSL gang member and associate. She was able to listen and detect hours of the goings-on of the enterprise. She learned throughout the course of her own investigation and during her time looking into YSL that a rival gang member, Rayshawn Bennett, ended up at the Fulton County Jail at the same time YSL gang member Jaden Myrick was there. The evidence will show that Jaden Myrick, upon seeing Lucci, reaches out to get permission from King's Line to take Bucci out. The evidence will show that Jaden Myrick actually endeavored to stab Rayshawn Bennett to death, but that he was unsuccessful. The evidence will further show that Jaden Myrick wasn't the only one reaching out to this defendant, Jeffrey Williams, for permission to commit a homicide. Looking at Shannon Stillwell's words along with his actions, happening upon the lyrics while trying to solve the murder, the evidence will show that law enforcement found one nugget spoken by Shannon Stillwell. I just beat a murder rap, paid my lawyer $30 for that, after he was released on bond for the murder of Donovan Thomas, and before he actually took the life of Shamel Drinks. The evidence will show that the young man on the left is Shamel Drinks in life, and that the photograph on the right is what was left of Shamel Drinks after YSL and the crater it created in the middle of the Cleveland Avenue community took that life from his family, friends, and loved ones. I said a lot, and I'm not the only one you can hear from today. So you might be happy, I'm about to sit down. I want to ask you to make use of those notepads and those pencils that you have in your possession. The court's already given you the instruction, take notes. Rely on your memory. Use the notes to document and help you remember after you've heard weeks and weeks and weeks and scores of witnesses who said what. I expect that as you listen to and evaluate witnesses who come in to testify, there will be witnesses who you discover changed their stories from the time they first made a statement to the time they actually had to appear here in court, in public, and tell on folks. I expect that the evidence will show that there are some witnesses you will assess are just scared. Some are embarrassed, some are intimidated, some don't want to remember, some just plain don't remember. The court alone gives you the law on how to deal with and how to assess those witnesses. I only ask that you follow closely the instructions that the court gives to you. Look at who the witnesses are. Look at who they look at while they're on the stand, who they don't look at or won't look at while on the stand. Look at how they answer questions posed to them from the state versus questions posed to them from the defense. And if the occasion arises that you find that a witness, as presented in court, says something different than what they said previously, you determine why it is you believe that they said something different once they got in court. Words and actions. The defendant's actions coupled with their words. They prove the existence of the enterprise. Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined in the indictment. Preserving, protecting, enhancing the reputation, power, and territory of the enterprise through acts including murder, assault, and threats of violence are what the evidence will show these defendants did over the last 10 years. The evidence will show that the violence didn't stop in 2015. Preserving, protecting, and enhancing the reputation, power, territory of the enterprise by the posting of messages, images, videos, and songs demonstrating their allegiance to the enterprise and a willingness to engage in violence on its behalf are what you'll see evidence of over the course of the next several weeks. Maintaining armed individuals, ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence, is what the witnesses and the evidence you will see proves to you. Obtaining money and other property through illegal activities like robbery, theft, and illegal drug sales and distribution. And obstructing law enforcement, killing 12 shifts. Investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. You'll see it for yourself. The children whose innocence this organization claimed as its own. And in the end, the evidence is going to show you that YSL is a RICO enterprise, nothing fancy about it. The evidence is going to show you that it's also a criminal street gang. Those two are not mutually exclusive. That these defendants participated in this enterprise in a way that had nothing at all to do with the record label, except maybe their actions as reflected in their songs made their music more real and perhaps more appealable to somebody. The evidence will show that the defendants, they talk about YSL while they talk about the crimes they committed. And while they talk about the crimes they're going to commit, you'll see that this evidence proves that YSL is a criminal organization. The defendants have been associating together for many years, committing crimes together against the general public, against rival gang members, as the evidence will show, against law enforcement, and against each other. The evidence will show they agreed, they willingly participated in these activities. In the end, the court has told you and will tell you again that you are to evaluate the evidence and apply that the law the court gives to you to that evidence and render a verdict that speaks the truth. I expect that at the close of this evidence, you'll see that the defendant's presence, companionship, and conduct during all of these illegal activities, their words and their actions, not only show the existence of the criminal enterprise called YSL, it also shows the conspiracy. And in the end, we're going to all come back and make our arguments to you. But the one thing that I'm going to be doing, our team will be doing, is asking you to uphold your duty and render a verdict, the only verdict that speaks the truth, and find these defendants guilty of each and every crime listed on this indictment alleged against them. Thank you.
Ladies and gentlemen, we've been going a minute. You want to take a comfort break? Anyone? All it takes is one, you know. Okay, all right. Two, see, and then everybody else will go after that. Let's take 10 minutes, and then whoever next would like to make an opening statement, I'll offer that to them at that point, okay? All right, so we'll be in recess for 10 minutes. Remember my admonitions to you. All right, we're in recess. got no court reporter.
The issue of elections.
I got no court reporter.
I understand.
All right.
Your Honor, if it's all the same to you, it doesn't need to be on the record for mine.
It does.
Okay.
Needs to be on the record for me.
All right.
No, I just read it.
All right, Sergeant Ingram, do we have everybody back, present, sir? Can I get all our attorneys to please kind of start making way toward your seats, please? Thank you, sir. All right. Have we checked on our jurors? Are they all ready, sir?
Yes, sir. Yeah.
Okay, all right. Mr. App, what do you need?
Your Honor, my understanding, I planned my opening arguments around I'm not using any PowerPoints. I didn't turn anything over to the state because I planned my opening arguments around using just paper and notes to speak to the jury off of, with the understanding that I was going to have a lectern to speak, to put those papers on in front of the jury. And my understanding was from Mr. Steele that there was a conversation with Captain Kendall last week that a lectern, which is in the hallway, would be allowed to be placed up there so that then those papers could be used. I understand now there's some disagreement or understanding about whether a lectern that's out there can be used or not.
I wasn't involved in that particular conversation, but I want to say that also, in order for us to for you to be heard, my suggestion is you probably use the podium. And there's plenty of room on the podium, that particular podium that's immovable, and it's also got a microphone. And you're welcome to walk back and forth, sir. You can walk around the well. I'll give you permission to do so. You won't bother me.
So I can tilt this?
It says,
there's a sign on
do
it.
not move.
Tilt.
Do not move. Do not. Yeah, because it's part of our evidence presentation system.
Well, there is a lectern on wheels that's 20 feet away from here that if we could just move it into the...
Well, you've also got the challenge of you got some jurors there available. So jurors that are sitting there closer, so I prefer you not do that, okay? You have to do the best you can with the table you have. Like I said, you can walk around. You can even put some of your stuff on the edge of the state's table if you'd like to. And also, related to that, if there's anybody in the media that is zooming in on any of the thing that's involved on any council table, please do not do that, okay? If you are, don't do it. So just please, I just wanted to make you all aware of that, all right? So, Mr. App, if you'd like to, since all this furniture belongs to me, technically, you are free to put your whatever you need on the edge of the state's table.
Can I use the witness stand when I'm giving my...
Yeah, sure. Absolutely. Absolutely.
I prefer the lectern, but I understand.
Yes, Mr. Sharp.
As a person who spent most of this morning trying to procure a lectern, there's also...
You didn't tell me, though, and we could have gone through this earlier.
I spoke to Captain Kendall last week. I spoke to numerous members of the Sheriff's Department this morning, and I was going through every procedure that I was supposed to go through.
Well, ultimately, it's my decision, right?
I understand.
Okay.
There is a much smaller lectern that can easily be picked up and placed here in courtroom 1D. It will literally take 2 minutes.
Sir, I want to move the presentation of this evidence. We could have discussed this weeks ago, and we could have gone ahead and planned it. I could have brought it over here and test drove it, but you didn't give me that opportunity, so let's move on.
Okay.
Thank you. Anybody else?
Sure.
Do you know what time, you still
No,
6 o'clock?
I don't know what time we're going to. But I'll let you know as soon as, I'll figure that out in just a little bit, Mr. Steele, okay?
Thank you.
All right. Who's making the opening statement next, if so?
That would be me, Your Honor.
Okay, all right. Let me know when you're ready, sir.
We're just going to set up on Zoom.
Okay, all right. Let me know when you're ready.
Your Honor,
Yes, Mr. Acton.
I'm gonna see.
Mr. Kokomo is helping me with the...
That's fine. That's fine.
Thank you.
That'll work out. And Ms. Weaver will yield some space to you, so, okay.
Being most accommodating.
There you go. We aim to please.
Oh, man.
I sent them to you, I think. Yeah, I think I emailed the first two to you, but I don't, the second two, Chris, Miss Love's gonna have to send them to you because they're password protected. So if you ask her to send those to you, she can.
Just mark the first one and then the last one.
Yeah, I went ahead. Yeah. You ready, young man? I think he said he's ready.
Oh, you ready?
Okay, all right. Can we summon our juror, Sergeant Ingram, please? All right. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
I would, Your Honor, on behalf of Mr. Stillwell.
All right, Mr. Sharp, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon.
Good afternoon.
My name is Max Sharp, and along with my co-counsel, the gentleman with the white hair back there, his name is David Botts. And together we have the honor and privilege of representing Shannon Stillwell. Shannon Stillwell is an innocent man. He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. He has been accused of a murder of Shamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State RICO law. He is not guilty. Now, I am going to deliver an opening statement that will preview what I believe and what I believe the evidence will show in this case and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwell, also known as Shannon Jackson. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwell, but he was raised by his paternal grandmother, Betty Jackson. So at times he's been a Stillwell, at times he's been a Jackson. He's indicted as Shannon Stillwell. I know him as Shannon Stillwell, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwell. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwell. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully, based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And finally, ladies and gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the press here today and different things about this case, this is somewhat of a unique case. It's drawn some attention. But the thing I want to stress is that this case is no different than any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwell, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt. Okay, ladies and gentlemen, the state started talking in their opening about about colors. About colors and hand signs and different markers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what colors mean in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill green. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places. Places of despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove apartments, which have since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. She raised him in the Forest Cove Apartments, and you'll hear that she loved him, poured love into him, called him her sweet thing, and he called her Mom because she was Mom. You'll hear that despite the love and guidance that Miss Jackson tried to pour into Mr. Stillwell, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper. You'll learn about the rap industry in this case. And you'll learn, and you probably already know this, but becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. It might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. How it's really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills and tried to make it in the rap game. But you'll hear that Shannon, like many other young men chasing this same dream, weren't making any money. And bills have to be paid. And kids have to eat. And rent becomes due. And in this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear how Shannon, trying to make it in rap, sold marijuana. The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some RICO conspiracy afoot. You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute, approximately 1 ounce, over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent in possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs. Okay? These are his path, his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past, but the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL, has nothing to do with the January 10th shooting of Donovan Thomas, and it has nothing to do with the 2022 shooting of Shamal Drakes. On count one, on this indictment, the state charges Shannon Stillwell with conspiracy to violate the RICO Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering. The state in their opening said, further the interests of YSL, further their goals. They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated than that. And in RICO, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table, to afford studio time to chase his dream as a rapper. I'm going to ask you, as close of evidence, to find Shannon Stillwell not guilty. Count one. Okay. The other color, besides dollar bill green and I guess bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county-issued jumpsuits that are typically navy blue, a deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all wearing the Fulton County blue. When Darius Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright, you'll hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claim they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destinies and they needed a favor. And they decided to insert themselves into a high-profile case that could solve all their problems. Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case. And the reason, this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gangman, that he was the leader of the Inglewood family Bloods in Atlanta, that he was high-ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, this shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you will see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January night, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015, and you'll hear that he gathered the evidence from the crime scene. There was no DNA, there was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or a Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You'll hear that he contacted the Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barbershops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, and he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out of the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Demekion Garlington. He was the driver of this car. Quindarius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back passenger side shooting a handler. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect, and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge, and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup, just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Demekion Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had 2 small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there, and the fact that there's gunfire going every which way, and how fast the car is moving, and you will be able to judge, was it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there who just signed those photo lineups that just helped our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright. So, the case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the name. The improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or he said to Spencer Wright, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again, and instead of writing a fake name, Nicholas Robinson, could you actually sign it your real name, Spencer Wright? And Spencer Wright did. So what happened? Detective Thorpe, on October 19, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Demekion Garlington, Kenneth Copeland, and my client, Shannon Stillwell. based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show McDaniel Street and catch the incident, but it also shows the MARTA park bench right across from the barber shops on McDaniel Street. And know who's in the know who's in the park bench? The bus MARTA bench across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment, so that others get arrested. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Demekion Garlington. They continue to push forward against Shannon Stillwell. Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up? Well, Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what Men in Blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue and they needed something, that's when they came up with their stories. I anticipate the state will call Quindarius Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quindarius Zachary is no longer wearing blue. Quindarius Zachary is not charged in this case. He got his deal. You'll hear about Kenneth Copeland. Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, found in possession of guns. October 28, 2021, guns, found in possession of guns, and he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how he'll do anything, anything. Just don't, please don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis, who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail, wearing blue, law enforcement comes out and talks to him. You'll hear his story. His story about how 2 cars were driving down McDaniel Street, and the first car sent a signal to the second car saying Donovan Thomas is just leaving the barber shop, as a signal like it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis' story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barber shop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that this car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis's story and compare it to the surveillance video and figure out how much value you should give his story. And finally, I anticipate you may hear from a man named Tremont Stillwell. A man who curiously claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Vanetta Guffey, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Tremont Stillwell was wearing at that time? You got it. When he was in jail for serious charges, and he needed help. He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth of the Fulton County Jail. And you'll hear that he claimed to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Tremont Stillwell was talking about and talked to his wife, who is now deceased. Her name is Vanetta Guffey. She is now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Tremont Stillwell's claims. That what he's saying happened, never happened, A, and that Tremont Stillwell is a effing liar. Those are the state's witnesses in this case. Those are the men in blue. Count 2 of this indictment is the count that charges my client, Shannon Stillwell, along with a whole new group of individuals with the murder of Donovan Thomas. There'll be no forensic evidence, there'll be no ballistic evidence. There'll be no eyewitnesses that presented themselves at the scene to say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwell was there or not. The state's case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay. Hold on one second, Shannon. Now, I would like to preview a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19th, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said wasn't completely accurate. No, it was a lie. Based on that, they broadcast to everyone that my client was responsible. And there has been repercussions. You'll hear in 2015, people pulled up to my client as he stood outside his store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us. You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs. The streets have not cared that Spencer Wright is a liar. Since that time, my client's life has changed in some small ways and some big ways that I make sense. Shannon Stillwell, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a sitting duck for IF gang members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of the IF gang members can know where he is. And yes, when he rents cars, he does tint their windows, so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask. That's been Shannon Stillwell's life since 2015. And I'm going to ask that you keep that into account as you consider the evidence as it's presented. Now, 7 years later, March 14, 2022. Remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They've just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scarier. On March 14, 2022, the evidence will show that Shannon, Quamarvius Nichols, Nikion Garlington, and Miles Farley were planning on going to the music studio to work on music, still chasing Hendrick. The evidence will show that Mr. Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows, and Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. The evidence, and you'll see, in this case, you'll see there's several different surveillance videos that you'll see in this case. The first being the BP footage. That's from the BP at the corner of Fulton Street and Windsor Street in Atlanta. And you'll see the video. And you'll see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You will see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do. I'm going to ask you to observe them on a video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just planning on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, and in fact, I believe that's a picture of it right there at that gas pump, and he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him inside the store. You'll see that he gets into some sort of argument or altercation, not an altercation, an argument. It appears with the clerk, and he leaves the store, and he gets in his car. There will be no interaction whatsoever between Mr. Drinks and my client, Mr. Drinks and Mr. Farley, Mr. Drinks and Mr. Nichols, Mr. Drinks and Mr. Garlington. There'll be no interaction at all. And you will see Mr. Drinks exit that parking lot and take a right on Windsor Street. And then you will see Mr. Stillwell exit that parking lot and take a right on Windsor Street. And then you'll see Mr. Nichols exit the parking lot and take a right on Windsor Street. And that's where the FedEx surveillance footage will take over. And you'll be able to watch the FedEx footage on Windsor Street, which will show these cars drive up and end up at a red light. You will see my client's car, white Audi, run a red light. You will see Mr. Nichols follow my client's car and run a red light. Eventually, cars come in to replace him, and traffic flow continues and continues for several minutes. And eventually, a man who's just happened to be going the other way, looks into Mr. Drinks' car, which is still sitting there, and notices that Mr. Drinks has been shot. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drinks. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred. So, this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwell, and let's be clear, the state is accusing Shannon Stillwell. I mentioned that there's 4 people in this party. They are accusing Shannon Stillwell of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see it and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it would show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwell. Remember what the state said in opening about how Detective Hogan had his case, and he had people on a video at the BP, which is near where the shooting occurred, but not where the shooting occurred. He had people on his video, and then he talked to another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwell. That's Shannon Stillwell. Oh, that's from Marcus Nichols." And they just ran with it. Yeah. Shannon Stillwell was at the BP that night. He didn't shoot Shamal Drinks. None of his friends shot Shamal Drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwell, and I'll tell you, the warrants were taken out and Shannon Stillwell was arrested in that same white Audi on March 17, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and you will, this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16th, 2 days after this alleged shooting, when every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Demekion Garlington's phone. Remember, Demekion Garlington was in Mr. Stillwell's car. And the state hinted at it a little bit. They were talking about Jaden Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, the state applied for, and you'll learn what a wiretap is, they applied for a wiretap and received a wiretap for Demekion Garlington's phone. The phone of the person who was with Shannon Stillwell on March 14, 2022. And you'll learn what a wiretap is, and how a wiretap really consists of law enforcement sitting and listening in on all your phone calls. incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occurred. You'll learn that this wiretap on Demekion Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamal drink shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't. It's secret. No one knows. That's the point. And you'll learn about who Demekion Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Demekion Garlington. You'll hear him on the wiretap, drunk, high, talking about everything under the sun. Pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now. But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and the state said they bragged about this stuff. State said Demekion Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up. Finally, and most importantly, the science about this March 14, 2022 case. We're going to learn about gunshot residue. Gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun and the gunshot primer that causes it. Synonymous with a firearm that has been fired. Who does gunshot residue testing? Georgia Bureau of Investigation, APD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part or an object, and you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on said item. You'll hear that Shannon Stillwell was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car, as pictured right there. You'll hear about Alexander Koven, a scientist, a man in search of the truth, a man who works for GBI, not for me, not for Shannon Stillwell. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Koven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Koven, as he was trained, took that gunshot residue kit and took those adhesive tabs and dabbed that headliner again and again and again and again and again and again. dozens of times. And then he wanted to make sure what he did was sufficient. So he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and he put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue, any at all. Looking for 15, 10, 5, 3, 1, whatever he could see. And you'll hear that on June 3rd, 2022, 77 days after the state, after Detective Hogan, Investigator Viverito, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwell fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. And on that headliner, there was not a single, zero gunshot residue to be found. That's the science. Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwell, my client. First is count 49 on this indictment. It is murder, alleging that he shot out of the white Audi and shot Shamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwell not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Act, Gang Activity Act, and they are essentially charges that say that Mr. Stillwell committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang. Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49, murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwell with possession of a firearm by a convicted felon on March 14th of 2022 on the belief that he used a firearm to kill Shamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And in count 54 charges Shannon Stillwell with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony. In conclusion, my client has been charged with 2 separate murders. He's been wrongfully accused of 2 separate murders, and we plead absolutely not guilty. He's been charged with conspiracy to violate the RICO Act. And while he has sold marijuana in the past, those were his decisions for his benefit and had nothing to do with YSL or anyone else involved in this case. He's pled guilty to those charges. He's done his time. That makes him an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules. Shannon Stillwell is presumed innocent. The state bears the burden of proof, and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of stories. Compare the credibility of a scientist like GBI scientist Koval, who followed all the rules and determined there was absolutely zero gunshot residue in that outfit. Compare that to what the state presents. Spencer Wright, who said his name was Nicholas Robinson, who lied to get out of jail. Spencer Wright duped Detective Thorpe on October 19th of 2015, and that is on Detective Thorpe. I am going to do my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be able to dupe anyone during this trial. My client, Shannon Stillwell, is not guilty. Thank you very much.
Ladies and gentlemen, how you doing? It's 5:30. All right, consistent with my earlier promises to you, I think it might be a natural stopping point for us to put a pin in today and for us to come back to more, unless you all object to my suggestion. Hearing no objection, I think we're going to go ahead and do that. So let's go ahead and kind of review a couple of things to begin with. All right, first thing is when you go back in your headquarters jury deliberation room, dump your notepads, okay? Hopefully everybody's written their name in the inside cover of those freaking ones like I told you earlier. But if you haven't done so, go ahead and do so. Take a juror sticker and put it in your pocket, your purse, or whatever carrier device you have, so that when you come back in tomorrow morning, we'll go ahead and you can put that on as soon as you get into as you come in through the being screened in the courthouse, okay? All right, you kind of figured out already for tomorrow if you need, and I think I mentioned to you this earlier, a lot of you wearing jackets and everything else, it's easier, like I said, for you to put on a jacket or for you to take off something than it is for me to kind of regulate the temperature. So please bring whatever it is that will make you comfortable tomorrow, your jacket or otherwise. Okay, that's kind of the ministerial, and if you're running late tomorrow, as I mentioned earlier, let Ms. Umana know, but remember, I can't start until I've accounted for all 18 of you, so it's very important you, again, as I mentioned earlier, only you know how long it takes for you to get down here to Fulton County from wherever you live in our great county. So just plan accordingly, leave a little bit earlier. It's always easier for you to sit back there and just kind of relax and don't be so stressed than it is for you to kind of leave late, and that just kind of just puts you in kind of a position you probably are stressed already when you get here. So I'd advise you to do that. Okay, you remember all my ad nauseam admonitions? They still apply, okay? So, very important, I mean, that you not talk about the case amongst each other as you're walking out. Do not talk about the case as you're in your headquarters jury deliberation room. Don't go on any social media sites. Do not let anybody friend you. Do not do any of the other things that I've told you earlier, like research anything, go by any scenes, take any photographs, or otherwise try and educate yourself to some things that you may have heard in the courtroom today. Remember, the only things you can consider are what's lawfully presented within the four walls of this courtroom. So it is very important that you consider and keep the court's admonitions, which I know you will continue to do so. There's great temptation when you go home tonight. Hey, what happened in court? Well, I saw you on TV. Are you supposed to respond to that? No, you're not. And you can blame me, you can even tell them Judge Glenville said for you not to do that, all right? Because remember, your doing that would affect, and if we found out about it, would affect our ability to have a fair trial, a just trial, lawful trial as to all parties. So please adhere to that admonition and all the others, okay? Remember, nobody's supposed to have any ancillary or incidental contact with you. If anybody tries to reach out to you, I need to know about it so you can tell Sergeant Ingram or any of my team if anybody should try and do so, okay? And consistent with my instructions when you were here before, we'll go ahead and get you squared away for those of you that are taking the shuttle and for those of you that need to make other alternative arrangements. We have just get with Sergeant Ingram, he'll go ahead and coordinate that for you, okay? All right, so you're probably wondering, what time are we going to start tomorrow morning? I need you all here to be here by 10 o'clock, okay? We will start somewhere between 10 and 10:30 tomorrow morning, and I'll do that, try and give that to you every single night that we conclude, tell you what time in the morning you need to come to be here. That's your target or mark time you need to be here in the morning. Try and get here a little bit earlier because then, like I said, you'll be a whole lot more at peace, and then as soon as we at 10 o'clock or thereabout, I can find out if all 18 of you are here, and I don't have to look for anybody. And then I can go ahead and we can get started once we're ready to pick up from where we left off from today. Okay? So, 1,000 hours tomorrow, you need to be in your headquarters. Okay, I think I've gone through all the things I need to with you. Any ministerial inquiry of me at this point in time, ladies and gentlemen? Anything from me? Questions? None? Okay. Ladies and gentlemen, thank you for your patience with us. And as I mentioned earlier, and I mentioned through this entirety of the process, the patience that you've given us are giving us today and will continue to give us throughout the consideration of this matter. So unless you have any other query or questions for me, I will release you until tomorrow morning and bid you comfort, and we'll see you in the morning. We'll start up when you all get here at 1,000 hours, okay? All right, so with that, ladies and gentlemen, have a good evening. All rise.
Ms. Hangerty and Mr. I made eye contact with you and asked you, please stop talking during all that. Please don't do it. Yeah, you just stop all this. I would appreciate it.
Okay. You want to pick them up in front?
Okay, ladies and gentlemen, please be seated. Our jury has left us and the door is closed. All right, so, counsels, tomorrow morning, first, before I go ahead and set the time for you all to be here tomorrow morning, Mr. Harvey, sir, have you talked with counsel for your client? Your client's spouse, I should say.
No, I haven't, but I can, and I will try to contact her. She was flying back into town after the holiday, so I did try to contact her. I'm going to do that right now.
All right, if you could ask her to be present for at minimum 9:45-ish tomorrow morning, I'll take it up somewhere between the 9:45 and 10 o'clock time period, and I can go ahead and get that done, or you can have a conversation with the state, and I can final that particular ruling, okay? All right, okay. So, counsels, if you all could be here tomorrow morning for approximately 9:30, and as I told our jurors, as soon as all of them are accounted for and we take up that last issue, then we'll go ahead and get started. What questions do you have of me? Anybody?
on behalf of Mr. Williams, sir.
Okay, so Mr. Steele, you have yet to make an opening statement, is that correct?
Correct.
All right, Mr. Matthews, you have not made an opening statement as of yet?
That's correct.
Ms. D. Williams, you have not made an opening statement as of yet, is that correct? All right, is there anybody else that I have not taken into account already? I'm sorry? It's just going out, that's all. You know? Yeah, it's kind of giving up on me today. I don't know what's happened to it, but yeah. Anyways, Mr. App?
Just that we would give them the same.
Okay, all right. So we'll start tomorrow with that, and then I anticipate, after we complete opening statements, stating you're prepared to call your first witness?
Yes.
Okay, all right. Any other inquiry of me at this point in time? Okay, hearing none then, folks. Appreciate your patience and diligence. I'll see you all tomorrow morning for an anticipated 10 o'clock start time. Please try and be here about 9:30, and then we'll go ahead and I'll take up Mr. Harvey's matter, and we'll go ahead and get started, okay? All right, we're in recess.
Thank you, Your Honor.
You're welcome.
Yes, sir.